You're listening to Soundside. I'm Libby Denkman. On Friday, the Supreme Court ruled that a Maryland couple could pull their child out of classes where the material involved books with LGBTQ plus themes. The 6 conservative justices ruled that parents should not be required to expose their children to class materials that go against their religious beliefs. Coincidentally, almost exactly 100 years ago, in July of 1925, there was another famous legal debate over what kids learn in the classroom that took place in Tennessee. The so-called Scopes monkey trial was ground zero for one of America's first culture wars, the debate over whether or not evolution should be taught in schools. Alexander Gazoulis is a legal scholar and associate professor at the University of Missouri School of Law, and he's also the co-author of the new book, The 100 Years Trial, Law, Evolution, and the Long Shadow of Scopes v. Tennessee. Professor, thanks for being here.
Thanks for having me.
So we're going to get into the comparisons between last week's ruling and the Scopes monkey trial in just a minute. But first, I'd love to get your initial reactions to the Supreme Court's ruling. Were you anticipating this? What was your initial reaction?
I was surprised by the scope of the ruling. The court has never before held that merely being exposed to curricular content that involves ideas that potentially conflict with religious belief, that sort of exposure to ideas has never before been held to burden the religious exercise of parents and students. That decision is going to have dramatic ramifications for the administration of public schools in a way that I think the dissent by Justice Sotomayor captures, and I think in a way that our history suggests as well, including the history you referenced of the many debates over evolution in schools that we've seen in the last 100 years of this country.
I have to say, the best resource I have for understanding the Scopes monkey trial goes back to the old Spencer Tracy movie, Inherit the Wind. And I don't remember where I saw it. I think I might have seen it in school at some point, in public school here in Washington State. But for people who maybe need a refresher, can you tell us the story behind the Scopes monkey trial?
Yes, and in fact, certainly the Inherit the Wind popularized the account of the trial, but was as Hollywood often does, slightly simplified version of what actually happened. But 1925 saw the culmination of a long-running movement brought on behalf of religious fundamentalist groups in the country to challenge instruction of evolution in public schools. That political movement led to some states, including Tennessee, enacting laws that banned teachers from instructing public school children on evolutionary theory, or any theory that conflicted with biblical accounts of creation. That was challenged by the ACLU, which organized a test case where John Scopes was taught evolution, was arrested and tried for the novel crime of teaching evolution. And the trial became a major focal point for American culture. It was broadcast. It was followed very closely, actually internationally even. It was one of the defining events of the era, and ended in some senses on a technicality. Scopes was convicted, but then the conviction was overturned on a technicality. Interestingly, and I think with great significance for today's moment, one of the effects of the Scopes trial that is less well remembered is that in the following years and decades, evolution faded from public school instruction. It was tended to be removed from textbooks and de-emphasized in the curriculum, in part because neither schools nor publishers wanted to go through that again. And I think that suggests some of the negative effects that might come out of the opinion that was issued last Friday. When schools are faced with the potential for hot button litigation spilling out into courts over contentious issues, history suggests that administrators will respond by de-emphasizing those issues from the curriculum.
How long did Tennessee have a law on the books banning the teaching of evolution? I mean, so Scopes was convicted. What occurred afterwards? I mean, how long did it take to actually get that law removed?
Yes. So the laws that a handful of states had these laws, and they were removed in the 1960s, largely either leading up to and in response to a 1968 Supreme Court decision that held that these particular laws were unconstitutional. Uh, Interestingly, though, in every decade since the 1960s, there's been at least one and often several federal court cases involving the teaching of evolution being challenged in some grounds. So even though the Supreme Court decided this issue in the 1968, that did not end litigation about the issue. It certainly didn't settle the issue in the eyes of dissenters.
I want to get to more on the kind of parallels we draw here because there are limits, right? There is the case today where the ruling is about parents being able to opt their kids out of certain lessons. And then there is a situation like in Tennessee in 1925 where the Butler Act had banned evolution from being taught at all. I mean, on the surface, one appears to be about parents' rights and choice, and then the other is about the state making the rules here. I mean, I could imagine somebody who's excited about the Supreme Court's ruling say, this is just, ideal to allow parents to decide what their kids are exposed to. What's wrong with that?
There's always been tension between the idea of majoritarian control over the school districts and the curriculum and the idea of individual rights, particularly of educators and students to receive information. The posture of these cases has changed from time to time, and sometimes they are brought as the state banning subjects, such as evolution in 1925. Sometimes they are brought as individual objectors to the curriculum, as we saw last week. The problem with framing purely along the lines of individual rights is that opt-outs of the kind that the objectors sought in last week's decision, Mahmoud, opt-outs do affect the curriculum for everyone. They affect the curriculum for everyone because it places quite a burden on the school to supervise children who've opted out, to arrange for space, to arrange for administrators to watch the children who've been taken out of the class because the parents objected to class content. There's substantial administrative burdens from that. There's also the challenge of anticipating what issues in advance are going to lead to parental objections. Again, the history of the teaching of contentious ideas suggests that schools respond to those sorts of challenges by either removing or de-emphasizing important material from a curriculum rather than trying to address every potential objection. And it should also be noted that there have been, throughout the history of public education in this country, objections to an enormous range of ideas. This is one reason why the dissent by Justice Sotomayor predicted that this is going to lead to chaos in the educational system. There have been, as I mentioned in the book, I document in the book, 100 years of battles over evolution, but also over books depicting magic, for example, books depicting the women's liberation have been challenged. There have been objections to instruction about the age of the earth. There's practically no limit to the type of content in a school curriculum that could be challenged as conflicting with a parent's religious belief. Now, that is not to say that all of those challenges would necessarily win if fully litigated in court, because there is a balancing test that courts would apply, and the majority opinion does suggest that some of the application might turn on the age of the children, for example, that younger children need more protection than older children from ideas that conflict with their religious beliefs. Again, the problem is that with all the other challenges that come with administering a public school, anticipating how litigation might play out in any of these issues, taking them to court for resolution is not appealing. What's the easier choice and maybe the only choice for many administrators is simply to remove content rather than litigate.
Take the books out of the libraries, take the books out of the classrooms. Don't have to battle this because teachers are busy, administrators are busy. So there have been a number of cases regarding religious freedom in schools in recent years before this Supreme Court. I'm just going to list a few of these. In 2017, the Supreme Court ruled that Missouri violated the Constitution when it barred a church preschool from a state-run program to resurface its playground. In 2020, they ruled that Montana could not exclude religious schools from a tax credit program used to provide funding for children to attend private schools. There was the Bremerton High School football coach praying after games, which was a big case around here in Bremerton, just across the Sound, that he was victorious, that the coach was victorious in order to allow him to pray. There hasn't been a universal victory for religious groups in front of the court, but have there just been a lot more challenges raised in recent years, or am I only tuning in lately, Professor?
No, there certainly have been more cases. The Supreme Court has accepted more cases on its merits docket involving religion than it had in previous decades. That is absolutely true, and it's partly the result of the Supreme Court reevaluating its approach to not necessarily so much the religious exercise cases, but dramatically diminishing its willingness to overturn actions based on the separation of church and state. To back up a little bit, the First Amendment has two religion clauses. One, the Establishment Clause, which guarantees the separation of church and state. The other, the Free Exercise Clause, which protects individual religious exercise. Now, sometimes those two concepts work together. So, for instance, in the old decisions holding that public schools can't make school prayer compulsory, mandatory prayer violates both the separation of church and state when it's imposed by the government. It also violates the personal religious rights of people of faiths who don't belong to the same faith group as the prayer. So they work together sometimes. But in recent years, the Supreme Court has overturned some older precedents involving the separation of church and state and been much less willing to enforce the separation of church and state at the expense of religious objectors. The Kennedy case that you referenced it stands in an interesting contrast to this one. There, you had a football coach praying on the 50-yard line of football games as a public school employee, and there was heated dispute in the record about whether students felt compelled to participate. And the court accepted, the majority accepted the view that this wasn't compelling people to participate. They had the option to participate, but if they didn't take up the option, they didn't have to. To some extent, that view of Kennedy stands in contrast to what just happened in Mahmoud. In Kennedy, they're essentially saying that merely being exposed to the prayer of the coach is not a burden on the exercise of people whose religion is different from the coach. Here, exposure to the curricular content, the inclusive literature on the LGBT community, the exposure is a burden on religious exercise. So again, I think there's tension between those two cases, though they are consistent in both ruling on behalf of the objectors and against the school district.
And I should say one of the exceptions to the favorable rulings for religious groups was this Oklahoma case where the Supreme Court said that Oklahoma could deny public funding for Catholic charter schools. This was a case where Amy Coney Barrett had recused, and so we don't know how that would have gone if she had been a part of that case. It was deadlocked at 4-4. So when we look at Mahmoud versus Taylor, this case out of the Supreme Court on Friday, allowing parents to opt their kids out of class lessons that involve books with like two gay dads or LGBTQ plus themes. You mentioned that Sotomayor is saying this opens the door to a lot more. Could we, out of this, see parents able to opt their kids out of lesson plans about evolution or about climate change or, say, vaccines and virology? I mean, we've had people being able to opt out of sex ed instruction for a long time. But where does this end?
Right. The sex ed opt-outs do come up in several of the opinions. The difference with that compared to, say, science education is that sex ed tends to be taught as a discrete unit, a one-off class that people can either attend or go to another room and wait for an hour and read. Evolution, for example, is foundational to biological instruction. It can't be disentangled from much else about the biology curriculum. And so it's fundamentally different from the sort in terms of the administration of a school from opt-outs, which are more common. Now, in terms of what we're likely to see, yes, I think history suggests that we will absolutely see requests for opt-outs from instructions related to evolution, and I think you're right about climate change and vaccine effectiveness as well. Whether those will be litigated, that's less certain. What you might see again is schools either finding a way to accommodate the opt-outs or simply de-emphasizing those subjects from the curriculum. I think we may also see legislatures attempting to codify requirements that schools allow opt-outs around certain subjects. Again, I think one likely effect of those sorts of laws would be seeing the importance of those subjects reduced in the curricular content.
I'm talking with Alexander Gazoulis, a legal scholar and associate professor at the University of Missouri School of Law. He's the co-author of a new book called The 100 Years Trial, Law, Evolution, and the Long Shadow of Scopes v. Tennessee, the famous Scopes monkey trial on the teaching of evolution in Tennessee classrooms. Professor, before we go, it's clear, as we've been discussing, that the Roberts Court is very open to arguments from religious rights groups. Where do you see this pro-religion bent of the court going next? Are there new frontiers besides the classroom or any new issues that you foresee coming up in the near future?
Well, you mentioned the Oklahoma charter school case, which was deadlocked and deadlocked because of a recusal. I think it's highly likely that you'll see a version of that case brought again in a posture that doesn't lead to Justice Barrett feeling the need to recuse herself, because I suspect litigants will at least want to take the chance that they'll get a favorable ruling with the whole court sitting on that decision.
Professor Gazoulis, thank you very much.
Thank you.
Thanks for listening to Soundside. By the way, this show is only possible because listeners support us. If you are able to give right now, check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org.